So for example, if Melissa has somebody at Sonata that, kind of needs help, but doesn't have the money to pay an elder law attorney, and maybe they try to do the application on their own, can Melissa or anybody from another assisted living facility call the Area Agency on Aging for help there? But what if their family member just decided, it's quick, I'm going to do it on my own, it's not a big
It
deal.
happens all the time.
They decide
walks
to-
over and go, do you know this person? Did they come through the process correctly? No, they did not. So then we call and educate them about what they need to do to get on the wait list.
That's excellent. So maybe with the other assisted living facilities and things like that, you could help the families understand, because that's an interesting thing that I'm seeing, come from a lot of people, the managing client expectations end of it, which is kind of nebulous when you're doing a fair hearing, right? We don't know what to expect. We can't tell them that there are specific rules, but that happens in fair hearings, that happens in the application process, and so it's interesting to be able to hear it from both ends, to be able to understand what happens when clients don't have an attorney, what happens when clients do have an attorney, what happens when clients can have the money to pay for a pooled trust but not necessarily need an attorney. And it's interesting, and the common vein through it that I see, and I'd love to open this up for discussion, is that client expectation. And so for those of you that aren't attorneys, and you have to help your clients through this process, what do you do? How do you start with them? How do you manage their expectations from the beginning? Because maybe they need help. Maybe they have family members that can afford to help. They cannot hire or do not want to hire an attorney.
We typically do one of two things. Either we try and convince them that if they don't hire an attorney, that they're never going to get off the waiting list and they're not going to get the Medicaid dollars that they need. So they might as well just hire an attorney and get it over with. Mm-hmm. Or we convince mom to fall and break a hip and go into rehab and have the Smith do the application.
That's very important.
Okay, go ahead, Nick.
Or what happens is they send them to us, we evaluate, okay, what program, so $1,700 she needs to be on QMB, so we do the application, help with the client, and agent eats that cost. They go through our provider funded, we get them QMB and give them community Medicaid, then we direct them also to the area agency to get them on the wait list to try to get that process. We do everything that we can to go through and we eat the cost. That's just one of our nonprofit missions.
Very generous of you.
So.
Anybody else? Go ahead, Ben.
I'm just curious if anybody knows, because I see the problem, I have the same problem. Something's denied, why is it denied? This is a simple case. I try to talk to the supervisor, don't get a response, I file for fair
Yeah, my
hearing.
CPA gets a statement, why didn't they tell me anything?
We work very closely with the CPAs and the attorney. That's something that I try and focus on because we all help each other grow that way. And one of the things is obviously in this world of today of the Vanguards, Fidelities of the world, the E-Trades of the world, where there's no services. It's great, there's no services, but when there's no services, there's no one calling the estate attorney, there's no one calling the CPA, there's no one calling this part. And that's missing, and that's when there's problems you need to look out. So we see it when we work with attorneys, like a soul couple who say, hey, why is this in so many different places? Because they're not working with anybody. And I think all of us here, the more we share with each other and can help each other, we'll have less and less of these senior issues because we're feeding on each other.
Yeah, I think the big takeaway is when you look at a client, whether they're coming to the financial advisor first, home health care, social services, legal, who's on your team? Let's fill out the roster. Who's on the team? Got a pretty sparse team here. There's really no one. We got to fill the team. And that's sort of, I think, the way you kind of plug and fill to see what the roster looks like. Just need to make any substitutions because we all need to be on the same page. And if you don't have other partners at work, then that's where you kind of, I think that will dictate your course of action more than likely.
For me to stop me giving money out? Is that the lawyer?
Right.
Okay, that's a new FINRA rule. There's a FINRA rule called FINRA 2165. Okay, and it's hold on disbursement of funds or securities, which I wrote it on the sheet there, specifically what it is.
Okay.
And in that situation, the first thing I'm supposed to do is call my legal department, and then legal department will go in here and do full analysis. And basically, it's financial exploitation or wrongful authorized taking, holding, appropriation, or use of specific specify, adult funds or securities or any act or omissions taken by a person, including through the sense of power of attorney, guardianship. I mean, it goes on and on. It's basically, but it's covering all aspects. So if I saw an elder care home something wrong, if I saw a bill, look, I have a client, she's getting billed $1,800 a month for her lawn. I called her up, I said, we pay her bill. I said, why are you paying $1,800 a month to pay your lawn? It's a lot of money.
Right, mini acres. $1,800 is a problem.
So this is what we did, and that's I think all of our responsibility.
Well, starting July 1, there's a new a court order.
Right, to exclude it.
To exclude it from my accounting, and that has saved.
Right, I mean, this wasn't one of our clients, again, it was us doing it on behalf of another office, but yeah,
So you can get, so if your board is maintaining its own checkbook, you can get a court order that excludes you including that in your, so what I have is on a monthly basis, I give my ward this amount of money, and then I get a receipt from, deposit in that.
Right, one of the other pieces that was certainly on some of my objectives for today was you also absolutely, and this, I know again for you guys it's a little premature, but you absolutely have to know what you can and can't do without a court order. I mean, your attorney certainly, at least on the financial side, we can clean things up if you screw it up. I mean, we can't obviously clean up a medical decision that goes the wrong way. But it's always better to ask before you do it than it is the cleanup after. So certainly never a check to yourself. I don't care if it's a legitimate reimbursement. Checks to cash are obviously a little messy. And you should be working off of some sort of budget. And other transactions above and beyond that are still going to be dictated by whether or not you need a court order for certain things. But know that up front so that then you're not telling the attorney after you've already submitted the audit or the accounting, because this is what I normally see, is somebody submits an accounting thinking that they did the right thing, and then the auditors come back and say, well, explain this and this, and then maybe had we known about it on the front end, we could have addressed it before that accounting even goes in, so the court orders would have been there for the auditors to see it on the back end. So it's that proactive piece again, it really is.
Up to the second floor to an empty patient room, and we sit down in our little chairs, and then a little young gal comes up with the tray, and she starts going off this checklist, and da-da-da-da-da-da, and I know what's going on out there, and I know what's supposed to be happening, so I'm just sort of watching how everything's laid out, and then next thing, oh, okay, well, so you guys are over the income and assets, and you've got this in policy and whatever, so you're going to need Medicaid planning. So she flips open her phone, and she gets somebody on the line from wherever, not local, and, okay, yeah, you're going to need a whatever, personal service contract, yeah, blah, blah, blah. And then they start rattling off, now that's going to cost you $750, then the application's going to cost you $2,700 or something, and now the girls are getting all like, wait a minute, my God, we're not talking about a lot of assets at all. So I'm like sitting there and I'm like, okay, I said, look, put on the brakes, we're not doing anything. And that was the end of that. And then I found somebody locally that I know, and we went through the whole process. And then I've been dragged in to other things on the backside where they shared with me the actual contract with Medicaid done right. They made a copy for me so I could read it, how you prepay this and we guarantee absolutely nothing. And how can you, if you don't have some grasp of the documents, the financials, to know what strategy you're going to utilize, how can you just, these folks that go, I can get you, no matter, I don't care what it is, I'll get you on, and then they get them to write a check. So it's bad.
Well, it's a felony.
And I've gone to the administrator of the nursing home, and one of them I knew, and I'm like, Adela, how did you get these guys in here? What are you doing? So I think getting to the corporate, like consulate, backing it up, and I've made those calls before.
Well,
I think that's what
the problem's something, most of the time, they would investigate. If they found enough information, they would have the person, who would be the offending person, sign what's called a cease and desist order, that they agreed not to do this anymore, complain to the Florida bar and they investigate. Because after they close the file, it's all public knowledge, it's all public information. You can get the whole file. So I have files on every one of these people. Okay, because I'm co-chairing the Young Licensed Practice of Law Committee for the Elder Law section last couple of years with John Fraser. And we collect all this stuff so that if somebody comes in or somebody has a problem, we at least have some background on these people. Well, this lady wrote a letter to the Florida bar, and I got it when I got her package. And she actually says to the Florida bar, I was doing all these legal agreements, I was practicing law. She actually says it. But then when the Florida Supreme Court came out in their opinion and said, we can't do this anymore, I stopped doing it. What she forgot and didn't understand was, it was illegal before the Supreme Court came out and said it. They were just putting in writing something that people ought to know. But it was always illegal. It wasn't like something new. She actually admitted she was doing telephone. But she printed up a card now. Now, I couldn't do this, but the lawyers in the room would get a real kick out of this. When you turn the card over, it says on it, Florida bar compliant. I couldn't put that on my card. So,
What does that even mean?
well, what does it mean? It means that she wants the public to read it and think it means something, but it means nothing.
Oh, so
And I can't believe the Florida bar would let her do that. So somebody sent it to the bar. I don't think they ever did anything about it. I'm not sure if they got it. I just haven't had time to send it again. But I mean, this is the kind of stupidity you see out there, what people are doing. But going back some years ago, so it based in the letter what the practice of law is, vis-a-vis Medicaid planning, and you cannot do this, this, and this, based on the Florida Supreme Court opinion. And they tell them, stop doing it. And then, of course, the people just throw the letter away and they keep doing it. So it got to a point where we just felt the bar complaints weren't enough. And so John Fraser, who would say my co-author on this book will talk about, basically,
this is supposed to be a problem too.
yeah, but let me correct what you said.
Okay, good.
The first part of what you said is 100% true, is most people, even that come to me, who have been injured, I had 3 people in 1 month come to me who went to the same planner, and they were all injured in 3 different ways. They didn't want me to do anything. Eventually, somebody sued this guy and got a judgment of 60 grand against him, because I have a copy of that. But these people just said, look, I'll pay you whatever you want to fix this thing up. I just don't want to, get involved in anything. I don't want to file complaints. So what Alice is absolutely true. Is trying to get people to file complaints can be very difficult. The other thing is that attorneys can file UPL complaints. John Fraser has filed over 20. Okay, he'll tell you that. He's the expert on how to do that. I always send people to him when they want to file a complaint. I say, he knows how to fill this thing out better than anybody. But the problem is, he will tell you that the system of UPL is complaint-driven, meaning they're not looking for attorneys to file complaints, even though we can file complaints. They want to see somebody come forward from the public who's actually been injured, who's gone, or even if they haven't been injured, they'll say, look, I went to a person, I didn't realize they weren't a lawyer, and they start telling me all about all this other stuff, and then I found out it's illegal for them to do that. Well, that's okay too, you can file a complaint like that. But I guarantee you the result will be, they'll send a letter to that person, their standard letter saying, you can't do this, 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 and this, which they ignore.
That same sort of criteria would obviously be a concern.
Right.
So it's not formally a personal right that's removed, but it kind of sort of is, because that's how the judges are addressing it. So it's coming down the pipe.
Even for someone that has not been Baker acted, right, this 790, so what constitutes a mental health? How is that defined?
And in terms, I think this is going to be a legal issue. It's going to be a major one. So statutorily, I have not had an examining committee report deal directly with firearm yet. I haven't seen that.
Palm Beach, right?
Palm Beach, correct. So I can't be an interesting issue because
It was just
the
as of
examining
July 1.
committee, yeah,
So-
July once this is all new.
So we don't know how a lot of this even comes out.
But when you say the exam, what qualifies someone to have mental health or mental incapacitated enough not to warrant owning a firearm? That's going to deal with, I think, the incapacity hearing to some degree. Even though it's recommended, you still have to prove it. And I think you're going to see more objections coming out because it is an amendment. When I say that it's amendment, it's really laid out in our Constitution. So it's always going to be a lot more different. Yeah, go ahead.